Hello, my name is Brian Carter. I'm a partner here at Michles Booth. I'm in charge of the workers' compensation department. And today I'm going to be talking about what happens if I'm injured and cannot return to my old job. That's a question that I get asked frequently, but before we can answer that question, we have to start with the broader question of how does workers' compensation work in the state of Florida. If you're injured on the job, you're entitled to two things. One is medical treatment, and the other is lost wages if, as a result of your injuries, you're unable to work while you're recovering or once you're placed at maximum medical improvement. And we'll talk about that in a moment. Uh, let's start with the medical benefits and how long you can seek medical treatment while on workers' compensation. That's a very complicated question, and the answer is as long as you still require ongoing medical treatment. In the state of Florida, if you're injured on the job, you're entitled to your medical treatment for the rest of your life, so long as the doctor says that the ongoing need for treatment is and remains related to the original work accident, and that the need for treatment is more than 50% caused by the work accident, as opposed to any pre existing or subsequent injuries that you may suffer. Um, the at some point during the course of your treatment, the doctor will place you at what's called maximum medical improvement. And all that means is that you're as good as you're going to get. You've recovered to the full extent. It doesn't necessarily mean that you've returned to your pre-existing condition. It just means that this is as good as medicine can get you, and the goal now is to keep you there. Once you're at maximum medical improvement, you're still entitled to follow-up care as long as you see a doctor at least once a year. The only thing that changes at that stage is that any office visit would have a $10 copayment going forward, but you're still entitled to treat with doctors for the rest of your life. In terms of your lost wages, they're the only thing that may actually end. A lot of people say, when does the coverage end? Well, when you're initially hurt, the doctor will place you on some form of temporary work restriction. During that time, if your employer is unable to accommodate your restrictions, you would be entitled to lost wages while you're recovering. Your eligibility for these lost wages terminates when the doctor places you at maximum medical improvement. At that point, a different question arises, and this goes to the what if I can't return to my old job? When you reach maximum medical improvement and your doctor assesses your recovery, if you haven't recovered back to your original condition, the doctor will assign permanent work restrictions. Whatever those restrictions may be, your employer will then assess whether those restrictions preclude you from performing the essential job requirements. If you can't perform your job, for example, if your job requires you to lift more than 25 pounds on an occasional basis and you have lifting restrictions of no lifting greater than 20 pounds, your employer can legally terminate you because you can't perform the job. At that point, the question then becomes of whether or not you're permanently disabled. In the state of Florida, permanent disability requires you or the worker to be able to demonstrate that you're unable to perform any work within a 50-mile radius of your home. That's 50 miles in any direction, based on a combination of your permanent work restrictions, your education, and your past work history. Now, keep in mind that I didn't say that you couldn't perform a job that paid the same as your old job or had the same salary. That's not part of the question. It's simple, can you work, yes or no? And I always use myself as an example. If I strike my head and suffer a brain injury at work in an accident, and could no longer be an attorney, but I could work at a fast food restaurant or do some other physical activity, I'm not entitled to any kind of diminished earning capacity. The question is simply, can I work? Yes and no. If the answer to that question is that you cannot work, then workers' compensation would be obligated to pay you until you're 75 years old. Now, I would tell anybody that while that might increase the value of your claim substantially, it also means that you've suffered a catastrophic injury and your life is going to be impacted forever. If you have suffered an injury on the job, I do recommend that you contact an attorney to address your specific questions and needs. You can contact us today for a free no obligation consultation. You can call us at 1-800-438-3606 or visit us online at www.michelsbooth.com. Again, my name is Brian Carter, and I look forward to talking to you if you have the need. Thank you.